Hey everyone, this is Willie Standiford with Standiford Stories, and in this video I wanted to discuss the 10th Amendment of the United States Constitution, what it means and its applications in simple terms. Now I know this video isn't directly business related, however, I think that we should all make it our business to understand our rights as they fall within the Constitution. Constitutional rights are extremely important. They're the foundation for a free society. If individuals are educated about their rights, they're able to exercise them. So, if you guys are interested in this kind of content or any of the other videos I've made on this channel, be sure to subscribe, hit the like button if you enjoyed this, and let's go ahead and get into the video. Okay, straight from Constitution annotated at congress.gov. The 10th Amendment reads, "The powers not delegated to the United States, the federal government, by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people." So, the powers not delegated to the United States by the Constitution, if it's not explicitly written into the Constitution to give the federal government that power, if it's not a power delegated to the federal government explicitly written in the Constitution, and if it's not been prohibited, if it's not a prohibited power by the states, if states haven't come together and states haven't written in their own constitutions powers not to be delegated to the federal government, then those powers are reserved to the state governments, respectively to the people. Because it's important to remember that state governments are representative of the people. The federal government is comprised of all the state governments, and it was never intended to be more powerful than the state governments. The state governments were supposed to be more powerful collectively than the federal government. But, obviously nowadays we're heading into a period of time where the federal government has too much power, has too much overreach, and is basically overriding what the state's will is. And remember, the states are representative of the people. If the federal government is overreaching to a point where state constitutions and state legislators have very little power against the federal government, then we've got a problem. In the earliest days of the Constitution, before it was even ratified, the opponents to the Constitution were very concerned that the federal government would grow to become too powerful, and that if there wasn't explicit writing in the Constitution that stated the limit of federal power, that the federal government would continue to grow and grow and grow. And that goes against the idea of federalism, so the 10th Amendment was more so a reiteration that the states reserve powers that have not been explicitly stated in the Constitution. If it's not written in the Constitution as a power delegated to the federal government, that's a power that belongs to the states. And in today's society, it seems like the federal government has been completely ignoring that, and the states really do reserve most of the powers that are not explicitly stated in the Constitution. That's all the 10th Amendment is reiterating. Now, I want to read a little bit here of an interpretation from the constitutionalcenter.org, a very great website, provides a lot of supporting articles and documents for constitutional amendments, specifically the first 10 amendments, which were the Bill of Rights. And originally, the Constitution was ratified under the assumption that a Bill of Rights would be entered into the Constitution, because you gotta think, the original Constitution did not include a Bill of Rights. And the opponents to the Constitution wanted a Bill of Rights. And so the Federalists basically came to um, they came to a middle ground with the opponents of the Constitution and said, okay, well, let's get this ratified. Um, we will amend the Constitution to include a Bill of Rights, so long, and the opponents of the Constitution agreed to that, and they came to a middle ground and were able to ratify the Constitution, and later the first 10 amendments came to include the Bill of Rights. So this 10th Amendment is more so reiteration that even though explicit powers may not have been mentioned in the Constitution or in the first 9 amendments even, this 10th Amendment really solidified the idea that the federal government has a limited scope of power only defined by the Constitution and defined by the states' rights and what the states want. Okay, so the original Constitution of 1788 contained very few specific restrictions on the ways in which the power of the national government could be exercised against the people. It guaranteed the right to trial by jury in criminal, but not civil cases, placed limits on prosecutions and punishments for treason, forbade bills of attainder, which are laws aimed at particular persons, and ex post facto laws, which are laws that punished conduct that was legal when it happened, limited any restrictions on habeas corpus to certain designated emergencies, and prohibited the granting of titles of nobility. But the Constitution that emerged from the 1787 Constitutional Convention contained nothing like a comprehensive Bill of Rights. That was what I was just saying. Most states' constitutions at the time had Bill of Rights, and many citizens, members of the Constitutional Convention, expected the new national constitution to have a Bill of Rights. Nonetheless, state delegations at the Constitutional Convention voted 10-0 against including a Bill of Rights in the Constitution. The sense was of the conventional delegates that a Bill of Rights in the context of the federal Constitution was unnecessary and even dangerous. It was considered unnecessary because the national government was a limited government that could only exercise those powers granted to it by the Constitution, and it had been granted no power to violate the most cherished rights of the people. There was, for example, no need for a provision protecting freedom of speech against Congress because, as James Wilson put it, there is given to general government no power whatsoever concerning it. Edmund Randolph made the same point regarding freedom of religion, emphasizing that no part of the Constitution, even if strictly construed, will justify a conclusion that the general government can take away or impair the freedom of religion. They maintained an inclusion of Bill of Rights would be dangerous because it might suggest that a national government had powers that had not actually been granted. As Alexander Hamilton had put it, a Bill of Rights would contain various exceptions to powers not granted, and on this very account would afford a colorable pretext to claim more than were granted. So, for why declare that things shall not be done, which there is no power to do? Moreover, any list of rights would be incomplete. Such a list might indirectly endanger any rights not included on it. So, the Constitutional framers thought that a Bill of Rights was appropriate for an unlimited government, but not for a limited one like the national government created by the Constitution. Again, the Constitution created a limited federal government and reserved most of the rights to the states, the people respectively. The Constitution accordingly sought to secure liberty through enumerations of power to the government rather than through enumerations of the rights to the people. Not everyone was convinced by these arguments. Indeed, the absence of a Bill of Rights threatened to derail ratification of the Constitution, especially in key states such as Massachusetts and Virginia. a number of states ratified the Constitution only on the express understanding that the document would quickly be amended to include a Bill of Rights. The first Congress accordingly proposed 12 amendments, the last 10 of which were ratified in 1791 and now stand as the Bill of Rights. The first 8 of those ratified amendments identified various rights of the people, such as freedom of speech, religion, arms, searches and seizures, jury trials, and due process of law. The last 2 addressed the concerns of the Constitution's defenders that these enumerated rights were pointless and even dangerous. The Ninth Amendment warns against drawing any interference about the scope of the rights of the people from the partial listing of some of them. The 10th Amendment, however, warns against using a list of rights to infer power in the national government that were not granted, in referring respectively to rights retained by the people and powers reserved to the people. The 9th and 10th Amendment also invoke themes of popular sovereignty, highlighting the foundational role of the people in the constitutional republic. So, the 10th Amendment's simple language, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. This emphasizes that the inclusion of a Bill of Rights does not change the fundamental character of the national government. It remains a government of limited and enumerated powers, so that the first question involving an exercise of federal power is not whether it violates someone's rights, but whether it exceeds the national government's enumerated powers. I think that this directly opposes to where we're at today. I think we could all, based on this information, I think we could all agree that the federal government has completely overreached their scope of limited power. They've used arbitrary and construed portions of the Constitution to defend their power. However, the 10th Amendment basically just reiterates that the federal government's power is one of limited scope. The states reserve most of the power. The states reserve the right to exercise power not explicitly granted by the national Constitution. And so, with that, it's not necessarily about protecting your rights, but it's a reiteration that the rights not explicitly stated in the Constitution belong to the people. The federal government shouldn't be making decisions that are not explicitly stated in the Constitution. They shouldn't be overreaching and attempting to do things that are not explicitly stated, especially if the states prohibit the federal government from doing so. So, hope this video was helpful. This is just my take on it. I think that constitutional rights are extremely important. I think it's important for you to understand the first 10 amendments as your Bill of Rights. If you're educated about your rights, you can exercise them and prevent an overreach of power by the federal and state governments. Thank you guys for watching. Thank you guys for sticking around to the end of this episode. If you guys found this video enjoyable, or if you found the information in this video helpful, be sure to smash that subscribe button, hit the like button for me. Really helps me out in pushing along that YouTube algorithm. And thank you guys again. Take care, stay safe, and peace.